Over the last few lessons, what we've been doing is talking about the processes which are in place which bring contracts to an end, the bringing to an end of a contract. This video is going to talk about undue influence. Now, the previous lesson we've spoken about the common law doctrine of duress when it comes to bringing a contract to an end, or voiding or creating voidability within a contract. This lesson, like I said, is going to move to looking at something of an equitable remedy. Now, it is an equitable remedy, which shares quite a few similarities with the concept of duress. And this is this idea of undue influence when it comes to contracts. There are differences and ways in which they differ, duress and undue influence. One, of course, is derived out of the common law, and the other one is, of course, derived out of equity. But we will speak about the meaning and the context in which these are created and established in this video. So, undue influence is, as I've mentioned, an equitable remedy which covers situations which do not amount to duress under the common law, but which do still at least illustrate the existence of what would be described as an improper amount of pressure by one party, which would then ultimately render an unfair advantage in the creation of a contract. So it is still very similar to duress in the sense that we see that there is an unfair and improper, an undue amount of influence and an unfair advantage which is created on one party as the result of pressure by the other. But it is still nevertheless not something which fits into the nice, neat category of the common law doctrine of duress. While the definition of undue influence in and of itself has been particularly undefined when we talk about the history of this particular doctrine, the courts have still yet been able to make a delineation between two different types of undue influence. We have in our corpus of understanding the equity of the law of equity or the rules of equity and our rules within contracts, we have with us two major categorizations that we can think about with relation to undue influence. Firstly, we have this idea known as actual undue influence. Secondly, we have this idea that we call presumed undue influence, both of which are very important. Now, this is the subject of the next two lessons, talking in the next lesson about actual undue influence on the one hand, and then in the lesson after that we're going to talk about the concept of presumed undue influence on the other hand. Two very, very important topics. But for now, and just finishing this lesson off nicely, we're going to think about the way and the process by which undue influence is shown. And to really illustrate this point, I would like to refer your attention to the Royal Bank of Scotland versus Ettridge, a case from 2002. Royal Bank of Scotland, by the way, I believe no longer exists as a result of events taking place in and around 2008. So, this case illustrates and involves a number of appeals. And all of these appeals will cover similar circumstances. There are numerous cases in our understandings on English law which have sort of similar kinds of structures, and each case involved the wife of an individual who had been charged interest as security for their husband's debts. And one of these claims sought to seek damages on account of advice from a solicitor who had advised her undue influence, advised her under undue influence from her husband. So had provided what would be traditionally defined as some kind of inadvertent pressure which advantages one side. Okay, the court made a number of considerations in relation to this case. They made it clear that, for example, a court will not permit transactions on the basis of undue influence owing to the fact that those transactions ought not to be treated as being the true expression of the individual's free will. So we're talking here about the ways in which the concept of this external pressure or this undue pressure, which advantages one side, has an impact on the genuine free will of an individual in making transactions and making decisions on this and in this case. They also made it clear that there was actually no rubric which explicitly makes determinations as to which instances are true undue influence, and those which are not true undue influence. And I've put in brackets there that that isn't particularly helpful for us, which is of course true given the fact that we are tasked with the job of trying to identify processes and to identify circumstances in which agreements, contracts, and decisions are made under contractual obligations, which may have been made under an amount of undue influence. The court also made a delineation between two different kinds of undue influence. What I've said is going to be the topic of the next two lessons. The first kind is this idea of actual undue influence. The second kind is this idea of presumed undue influence. And just as a basic introduction to the next two lessons, when we think about actual undue influence, we see here that there is a process by which the burden to show that there is an undue influence is in fact on the party who is claiming to have been the victim of an undue influence. When it comes to such cases of actual undue influence, the standard of evidence will depend on the factors specific to the relevant case. And then on the alternative, where there is presumed undue influence, there will be 2 points of proof for the presumption of undue influence. These include the existence of trust and confidence in one party, something akin to a fiduciary relationship, and then secondly, a transaction which may call for an explanation. Again, something that we're going to focus on in more detail when we get to that lesson in the future.